Okay, let's go. The moment we've all been waiting for. Jeff Rath on CBC. We'll take a look at this clip. I'm watching it for the first time. I'll be reacting, but I really won't hop in that much. I'll mostly just kind of enjoy the clip. I heard Rath cooks here. We will see.
Jeff Rath from the Alberta Prosperity Project. Jeff Rath, it's good to meet you, sir. Thank you for giving us some time today.
You're welcome. Thanks for having me on.
You said after the judgment came down yesterday that there are numerous errors of law in this decision that you will be appealing. What is your main argument that this decision should be overturned?
Oh, we have so many, but I mean, one of the big ones is that she hadn't even ruled on what the record was prior to the hearing. So the province had brought an application to strike huge portions of affidavits that were before the court. So we go through this hearing without anybody actually even knowing what the record is. There's a Latin phrase, it's called audi alteram partem, and that is that, you have to know the case that you have to meet. It's a fundamental error for a judge to allow a case to go forward before she's even defined what the record of the case before the court is. But I mean, that's actually, even though that's a fairly major ground for appeal, that's the smallest part of the errors that she made in this case, right? One of the interesting things about this decision, and this is what creates the big political problem for Danielle Smith that you might want to talk about, is that she ruled at paragraph 76 that even though it's unconstitutional and illegal for citizens to express themselves democratically by getting together and signing their names on a piece of paper to communicate their wishes, kind of like a letter to Santa Claus, going to the legislature saying we want a question on the ballot. Even though she said that's illegal, she ruled clearly and expressly that it's not illegal for Premier Smith to call the question herself under Section 1 of the Referendum Act, right? Which is the same thing that Justice Feasby said. So, one of our questions for the Court of Appeal is going to be, logically, how can the mere act of citizens putting their name on a petition, asking the government to do something that they have the jurisdiction to do under Section 1 of the Referendum Act, in some way offend a treaty or Aboriginal right? Gathering signatures, was any Treaty 8 Indian prevented from hunting in the Northwest Territories, Saskatchewan, or British Columbia? Were they prevented, from, fishing or trapping or anything by, mere signatures being put on a piece of paper? Of course not.
Well, if I can jump in, just so the audience can, I can try to explain to the audience here some of the reasonings the judge spelled out here. I mean, essentially the way the citizen initiative law works in Alberta is that if you get the signatures and they get certified, then it will go on the ballot. And because a referendum like the one you are seeking is an issue of a constitutional question, the law says it would be binding. And what the judge has essentially said is, because it is a constitutional question and it would be binding on the government to follow it, that would trigger a duty to consult under the principles of the Haida decision, that if the government knows it might affect treaties, if they are contemplating action that would affect treaties and recognize there would be potential adverse impacts on those treaties, there is a duty to consult, whether it's a citizen initiative or a government initiative. So
she's wrong about all of that.
Why is she wrong?
Well, I'm just going to start with paragraph 76 of her decision, where she says, although pursuant to Section 1 of the Referendum Act, Lieutenant Governor and Council retains discretion over holding a referendum on any question relating to the Constitution of Canada or relating to or arising out of a possible change to the Constitution of Canada, that discretion is not applicable to referendum questions arising under the amended CIA. Well, how is it legal for the government to call the question itself under Section 1 of the Referendum Act and perfectly constitutional, but it's unconstitutional for citizens to just put their name on a petition and say, hey, government, we want you to call the question?
But is the ruling that the signature process was unconstitutional, or that this process can't? No, well, what's unconstitutional, they argue, is that the duty to consult wasn't met before this process was allowed by the issuance of the petition.
Okay, but the problem is that she doesn't understand the way that the duty to consult works in Canadian law, okay? There has to be an actual infringement of an actual right. And again, try to keep up, right? How is anybody's right infringed by people putting their signature on a piece of paper? Nobody's rights were infringed by that. How would anybody's right be infringed by the Elections Alberta counting these signatures and transmitting that number to the government of Alberta? Nobody's rights are infringed. No, let me finish, okay? Just let me finish.
Yep.
So, and again, even holding a referendum, nobody's rights are infringed because the government, the secession reference of the Supreme Court makes it clear that even holding a referendum, and even if there's a yes vote in a referendum, doesn't affect anybody's legal rights. And of course, the judge completely ignored that in her decision. And of course, the only way that rights would be illegally infringed under the Canadian Constitution was if the government were to completely disregard, and that would take both Canada and Alberta, in the event of a yes vote, if they were to completely disregard Section 35.1 of the Constitution Act 1982, which says for government powers with regard to Indians, treaties, etc., to be devolved to another government, so federal powers devolving to the province, right? There has to be a constitutional conference under Section 35.1 of the Constitution Act 1982.
Right.
So what that means is that if there was a yes vote, and if the governments didn't convene a constitutional conference, or if First Nations thought their rights weren't addressed in good faith in the context of that constitutional conference, right, then they could come to court. But until then, this is all purely speculative and hypothetical, and I can show you half a dozen decisions from the Supreme Court of Canada that say that you don't have an obligation to consult with regard to speculative and hypothetical questions.
Well,
so that's the law as we understand it. Those are the issues that we're taking forward to the Alberta Court of Appeal.
But on that point, just you pointed to paragraph 76. I'll point you to paragraph 232, where the judge talks about the conditions under the Haida test, and again going back to the contemplated conduct, that if the Crown will act on something, and acting on a successful separation referendum would obviously affect the treaty rights of Treaty 7.
It wouldn't obviously.
Okay, but she says that once an initiative petition is approved and the required signatures are obtained, the executive must hold a referendum and must implement the results of the referendum. So if it goes ahead and you win, they are bound by the law to implement it, and then it will be too late to start the duty to consult because it will be happening after a decision has been made and found binding on the executive, and that infringes on the rights to be consulted in advance.
Sure.
The right to be consulted is just so clown world. I'm not going to really hop in much. I talked about this in a prior video, but what do you think that means? Isn't just, hey, we're doing a petition. That's enough consulting, I think. I think to any rational person, what? Does that even what you want to be sit down and fed some meal and say, hey, just so you know, we're doing this? What the fuck, man?
Is the fundamental argument
all
here.
Wrong.
What's that?
We say that's all wrong. So yeah, that's what the judge said. We're obviously appealing her decision because we say that's wrong. And the reason we say that it's wrong is because the Supreme Court of Canada itself in the secession reference said that nobody's rights are engaged even in the event of a yes vote in a referendum, because simply citizens expressing their opinions on something doesn't affect anybody's rights. The Supreme Court has made it clear that it's a political process. And what we have here is this is the second judge now that's decided that they want to engage in politics and they want to be a political actor rather than a judicial actor, and to basically engage in politics while wearing a black robe with a red sash. And quite frankly, in our constitutional system, that is completely inappropriate.
So let's go. Jeff Rath. This, I think, is his best appearance since the Vashey CTV appearance. Maybe that was 3 months ago. Jeff is cooking here.
So, Mr. Rath, you're going to appeal. The Premier says they're going to appeal because she's on your side, that she feels the judge has made a decision there. The target for this referendum has been October 19th with the other 9 questions the government is putting forward. Can this all be resolved by October to actually, get your signature certified and get your question on the ballot, or do you think it could push it past that window?
Oh, my God. That's the Canadian culture. Let's just kick the can down the road even further. That happens on so many things. Real quick, too, the duty to consult. It sounds like the First Nations that are mad about this, they actually just want a veto. Oh, you didn't come to us and let us veto your petition. Again, a duty to consult. That's just so ridiculous.
No, absolutely. I mean, one of the first thing we're doing is we're drafting and filing a notice of appeal, which we are going to have filed by either late tomorrow afternoon or Monday, for one. Mm-hmm. And then simultaneous to that, we're working on a stay of this decision, effectively, a court order from the Court of Appeal setting this decision aside so that Elections Alberta can do its legislatively mandated job of counting our petition signatures or verifying our petition signatures and communicating that information, to the Lieutenant Governor and Council through the Attorney General. That being said, though, and this is the importance of paragraph 76 and actually the decision of Justice Feasby, both of those judges, again, as far as I'm concerned, playing politics, have made it clear that Danielle Smith herself can call the question anytime she wants. So she can actually call the question, notwithstanding the fact that her government's appealing, notwithstanding the fact that there's ongoing court processes. She can put our referendum question on the ballot under Section 1 of the Referendum Act, regardless of any court processes going forward. And that's what 301,620 Albertans expect her to do. And I think she's going to learn quite quickly that almost a unanimous base or the unanimous membership of the United Conservative Party expect her to do, because even the 33% or so of the United Conservative Party that are not in favor of independence are 100% in favor of democracy and are of the view that people in Alberta have the right to vote yes or no on this question.
I think that's right. I even saw people today on X who were against independence saying that this ruling from the judge was ridiculous.
So, Danielle is literally facing politically what I consider to be an existential choice or an existential turning point in her leadership. She can either decide to accede to the overwhelming will of her members or the members of her party, or she can lose all moral authority to lead the United Conservative Party and should likely go the way of Jason Kenney.
Okay, so
I think that's pretty much correct from Rath there. I do think that's the politics now of the situation for Smith. What do you think? Do you agree with that? Yeah, I agree with what Rath said there 100%.
yes, the government could try to move ahead with this referendum. They would still have to meet the threshold of the duty of consult because they are acting on behalf of the
No,
Crown.
they don't, sir.
Well,
you don't understand the law.
They're the Crown.
They do not have to consult. And that's exactly what Justice Feasby said, and that's exactly what Justice Leonard said. They basically say you have to consult if you go under the Citizens Initiative Act, but you know what? If you do it under Section 1 of the Referendum Act, there's no ability whatsoever for the court to get involved, because even Justice Leonard agrees at that point the Supreme Court of Canada in the secession reference says the courts have no role to play and no jurisdiction because it's a purely political issue. So, and I'm sure that the First Nations, because they're being funded.
Let's go. That was brilliant.
Funded by the Tides Foundation and funded by George Soros and funded by foreign money, will fight every single step of the way because they have billionaires backing them. But at the end of the day, we are pushing ahead. Our movement is not deterred by this, and we will have a referendum on October 9th.
Well, Mr. Rath,
that was beautiful. That's what CBC has been missing. Actual disagreement. The other side of the aisle. Some of these people that go on CBC, some of them, by the way, are smart people, but the conservative on the panel is generally centrist or maybe center-right. I think sometimes even center-left. So there's not actual diversity of opinion. You need people like Rath on CBC more often if you actually want to have an effective media in Canada. I know that, anyway, CBC just bats like crazy for left-wing politicians, but anyway.
You've been meeting with the Americans, like you've been going across the border, have you not, and talking to people?
We're not funded by.
Have you asked them for? But have you asked them for?
He plays that card. Oh my gosh, David Cochrane is out of his element. David Cochrane is getting smoked in this interview by Rath. Wow.
They don't instruct our court cases. They don't hire our lawyers. Please, let's be realistic here. I just bring that up because the other side was raising these silly foreign interference arguments in the context of this court case, when they're the ones that are actually being funded, by foreign sources and, that are tied to communist China. So, let's be clear here. And I've heard you talking about this with other guests on your program and Jason Kenney and others. So I just wanted to sort of balance out the record because, typically the commentary on your show is very unbalanced when it comes to Alberta independence.
Yes.
Okay. Well, Jeffrey Rath, I'll give you the last word there on that. Thank you so much, Jeff Rath, for joining us with the Alberta Prosperity Project. Thank you, sir.
My pleasure. Thank you for.
Dude, that was great. I didn't know exactly what to expect, but Jeff Rath, I think, hit that one out of the park. Amazing. I'll finish the video there. Let me know your thoughts in the comments. Like, subscribe. Have a great day.